Hello, my name is Montague Haight. I'm a student at Seminole State Community College. Today I'm going to talk about Terry versus Ohio, the 1968 decision um, that gives an officer the ability to take and stop someone, pat them down for weapons in a stop and frisk or a Terry stop. On October 31st of 1963, while in downtown Cleveland, a police officer um, Detective Martin McFadden at the age of 62. He saw two men that were going back and forth in front of stores in what he considered a suspicious manner. He felt that the two gentlemen were casing multiple stores. At one point in time, another individual arrived, made contact, and then that individual immediately left. From there, the police officer followed the two individuals, Terry and the other gentleman, from where they were a few blocks away to where they met back with the third individual. At this time, the detective felt that he needed to stop them and speak with them, pretty much interrogate them in regards to their suspicious behavior, because the detective was very well known for making his arrest for pickpocketing and for observing circumstances like this, and he felt that he had enough reasonable suspicion, which we'll get back to that, to stop these individuals. So the officer did. Officer McFadden stopped the two gentlemen, Terry and I believe it's Clinton, and spoke with them, and he did an exterior pat down. So nothing invasive. He didn't go in anybody's pockets. He didn't go underneath their garments of clothing. He did an exterior pat down. Well, as he was patting down Terry, he felt a weapon. So for his safety, as well as the safety of Mr. Terry and the other individuals that were there, he put all three of the suspects up against the wall and removed the revolver from Terry's clothing. And at that point in time, he did go underneath Terry's garment to remove the pistol. That was only after the exterior frisk found that he had a weapon. So from there, the detective searched the other two, patted them down, exterior searches. And at that point in time, the detective found another revolver on the other gentleman. And at that point in time, he also went underneath the individual's garment and removed the pistol. The third individual, which is very important, the officer did a pat down of the exterior garments, found nothing. So the officer didn't go and do an invasive search, didn't go under that gentleman's garments for any reason. From there, he took the individuals back to all three of them to the station, where he conducted interviews with them and subsequently charged two of the individuals with possession of a concealed firearm. Terry and the other gentleman both were found guilty of possession of a concealed firearm, and then they immediately appealed that decision with the Ohio Supreme Court. Well, from there, the Ohio Supreme Court reviewed everything and said that the officer had reasonable suspicion to believe that a crime was being committed or had been committed by these individuals, and that by him stopping them, talking with them, it did not violate the Fourth Amendment rights for illegal search and seizures. So they immediately threw out the ruling, they immediately threw out the request, I should say, for the dismissal and a motion to suppress both the weapons, because they also had done that during the trial. So they threw it out. Said, nope, it was a good stop. So in 1968, it went in front of the U.S. Supreme Court. It came into rule that officers now have the Terry versus Ohio ruling, which gave officers the opportunity to stop and frisk someone, or Terry stop. It's a brief detention. Brief. That's the whole key here. Brief detention that an officer has a reasonable suspicion that you've committed a crime or that you might commit a crime. So the Supreme Court, though, the funny part is, has never given a true definition of what reasonable suspicion is or what probable cause is. So it's up to the officer as an individual to go, I think that they've done a crime or they've committed a crime or they're going to commit a crime. I'm going to stop them. It's based upon that officer's training and experience to determine whether or not he feels he has reasonable suspicion, not probable cause, reasonable suspicion, to stop you, pat you down for weapons. And if he chooses and feels that he needs to pat you down, he can. So it was a landmark decision, huge decision in police work because, again, it took from having to have probable cause and going, I saw Johnny rob a bank, and the officers being able to stop you to going, Johnny robbed a bank and he was 5'10" and he was wearing, a white shirt and blue jeans, and then an officer walking down the street and going, well, there's a guy 5'10" wearing white shirt and blue jeans. I'm gonna stop him and see if he has, thousands of dollars in cash on him or has a weapon on him. So that gives the officers the opportunity to do a pat and frisk. All under Terry versus Ohio, 1968. Very, very landmark decision. It's probably one of the larger landmark decisions in law enforcement history that I have viewed, especially since it refers to the Fourth Amendment. I hope this gives you a little bit of an idea of what Terry versus Ohio is. Enjoy. Look forward to seeing you guys in the next class.